All right. If you are prepping for the Australian bar exams, you know there are some cases that are just, well, they're non-negotiable. Today, we are diving into one of those absolute giants, R. v. Edwards. This is the High Court case that definitively answers a huge question. When is a trial so fundamentally broken that you can't even let it begin? So picture this. It's the night of October 23rd, 2001. We've got a Qantas Boeing 737 at Launceston Airport in Tasmania. The control tower is empty, the runway is pitch black, and whatever happened in the next few minutes led to two experienced pilots facing charges of recklessly endangering life. The incident itself was pretty dramatic, for sure. But, the legal fight that followed was arguably even more intense. The core of the case shifted from what happened on that runway to a much bigger question. Was a fair trial even possible anymore? Okay, so to really get our heads around the legal arguments, we first have to understand the facts of what went down on that tarmac in Tasmania. Here's the play-by-play. The plane lands just after 10:30 p.m., and yup, the runway lights flick on just like they should. A couple of minutes later, it's at the terminal. But then, fast forward to just after 11 p.m., it takes off. And multiple witnesses, we're talking other pilots on the ground, all said the same thing. The runway was completely dark, no lights, nothing. Now, at the very heart of this whole story is a little bit of tech. You see, the runway lights weren't just on a regular switch. They used something called a pilot-activated lighting system, or PAL. To get them on for a 32-minute cycle, the pilots had to ping the tower with 3 very specific radio pulses. Now remember that detail because it becomes absolutely central to everything that follows. So the pilots insisted they'd activated the lights. The witnesses said the runway was dark. With the scene set for a classic courtroom battle, the defense team made a really bold move. They asked the court to just stop the prosecution in its tracks. They applied for what's called a permanent stay of proceedings. And this, in the legal world, is the nuclear option. It is a massive deal. It's the court basically throwing a knockout punch, saying that to even let the trial go ahead would be a grave injustice, an abuse of the court's own process. It's a tool that's only pulled out in the most exceptional of cases. So why on earth did the defense think this was one of those exceptional cases? Well, their argument really hinged on 2 main things. First, lost evidence. The flight data recorder, the one piece of tech that could have proved if the pilot sent those radio pulses, was overwritten after just 15 days. Gone. And the airport's own log of light activations, also gone. The hard proof had just vanished. And second, the delay. The pilots weren't even charged until nearly 2.5 years after the event. And in a decision that I'm sure shocked a lot of people, the Tasmanian Supreme Court actually agreed with them. The judge, Justice Slicer, granted the permanent stay. The trial was off. For the pilots, this was an incredible victory. But for the prosecution, it was a decision they believed was based on a massive legal error. Now, the prosecution wasn't about to just let this go. They appealed. And they didn't mess around. They went straight to the top, to the High Court of Australia, arguing that the trial judge got the legal test fundamentally wrong. And right here, this is the exact phrase where the entire case pivots. The judge asked whether the trial could constitute an unacceptable injustice. The entire appeal, everything that came next, hinged on that one tiny 4-letter word, could. So why was this one little word, could, such a big deal? Why was it a critical mistake? Well, because for such a drastic measure as stopping a trial, it sets the bar way, way too low. So the case lands in the High Court, and they use this as a chance to set the record straight in a judgment that, as I said, every aspiring barrister now has to know inside and out. And the High Court's correction was just crystal clear. They said the test isn't whether a trial could be unfair. The proper test is whether the trial would be unfair, or, to use their very powerful phrasing, so unfairly and unjustifiably oppressive that it abuses the process of the court. I mean, that's the difference between a vague possibility of unfairness and a near certainty of it. It is a monumentally higher standard. The High Court also laid out some pretty practical truths about how the justice system works. They explained that trials are always imperfect reconstructions of the past. Evidence gets lost all the time. Witnesses' memories fade. But that doesn't automatically make a trial unfair. And critically, they pointed out that since nobody had any idea what that lost data actually said, you couldn't just assume it would have helped the defense. For all anyone knew, it could have proven the prosecution's case. So its absence was neutral. It didn't help or hurt either side. And so, Based on all of that solid reasoning, the High Court allowed the appeal. They overturned that permanent stay, and they ordered that the trial had to go ahead. Okay, let's wrap this up and really focus on why this is such a landmark case and what you, as a future lawyer, really need to take away from it. So here it is. This is your bar exam cheat sheet for R.V. Edwards. First, the threshold for a permanent stay is exceptionally, unbelievably high. It is a remedy of last resort. Second, the correct test is would be unfair, not could be. The defense has to prove it. Third, just because some evidence has been lost, that's not enough to kill a trial, especially when you don't even know what that evidence would have shown. And finally, and this is a big one, the law guarantees a fair trial, not a perfect one. The High Court in Edwards drew a really clear line. But it does leave us with this pretty profound question that courts have to grapple with every single day. While a perfect reconstruction of the past is impossible, at what point does the picture become so blurry, so incomplete, that a jury can't possibly be sure that it's seeing the truth? That's the tension right at the very heart of criminal justice.